All right, we're having a legal conversation. It is Justice Thursday after all. And our guest is here. Kepher Ojijo is an advocate of the High Court of Kenya, managing partner at Ojijo Senaji and Associates Advocates. Good morning.
Morning.
How are you?
Fine, thank you.
Karibu sana.
Asante.
So, emerging legal trends, those are some things that, some buzzwords that have already been used here and there. People are talking about them. And employee discipline or indiscipline. What can you do? What can you not do? What can I be suspended or not suspended for? Termination, dismissal. What are my rights? There are a lot of things. There are a lot of things that are buzzing. There's a lot of chatter around that. And those are some of the things that we'll be delving into today. Welcome to the hot seat of the Situation Room, Wakili. Good to have you here. Before we turn up the heat a little bit, City's going to. It's like the proverbial frog in the warmer of.
People have roasted.
Oh no! At least we'll say hello. And City has a proper way of saying hello with a proverb. And this week they're from the Republic of Congo.
Yes, okay. Otherwise known as Congo Brazzaville. Mm-hmm. Because of waiting too long, the gorilla lost its tail. Let me tell you now how they would say it in their language. Zela zela, mokomboso azanga mokila. Not that I know what means what where, but there it is. Because of waiting too long, the gorilla lost its tail. Yes.
Interesting. It is interesting, isn't it?
Very interesting.
What does that mean to you? How would you unfold that?
In real perspective, I think I'll put that in a situation that certain fact or certain actions required to be dealt with in a prompt manner, so that the more we delay, the more we lose touch with it, and the more the impact become less felt to the people, and probably we shall have lost an opportunity. So I feel it requires people to act timely and promptly on situations as required.
Indeed. Do it now. While the opportunity presents itself.
No, that is perfect. You see, the beauty of asking for someone's interpretation, it can't be wrong. Because that is how you resonate with the proverb. So thank you. Yes.
Okay.
You need to respond to things expeditiously. Yes.
Well done.
No procrastinating.
Ngoja umiza watu.
Bas.
That's what they say.
Procrastination.
Yes.
That theme. That's a story for another day.
It is a story for another day.
Yeah. Procrastination. Let's talk about it tomorrow.
Yes, we shall.
Okay. So, all right. Emerging trends. We're looking at a lot of stuff happening in the employment space, right? Yes. Wakili, many issues over time. Indiscipline, discipline, termination, not to be terminated, dismissal, what it actually means, what can or can you not do according to the law of employment in the country. Let's just start off with some of these things. What would you say is the situation now in terms of understanding what employees can do from an employee perspective, and then what is then demanded of employees from an employer's perspective?
When I was driving here, I was just talking to my client, my governor for Homa Bay, and she was asking me now, what do they do with their doctors? Because these people seem to be a thorn in the flesh for them. I mean, they're not going back, they're not settling down, and they feel, the health sector is deteriorating further and further. And now they're asking, what are we going to do? I mean, do we fire them right now? Do we stop their salary? What do we do? I think those are some of the things we are going to discuss, because it is unfortunate that there's a lot happening in this country right now. Strikes all over, and then this I think because of the economy, there's a lot of redundancy, people being laid off, right, left and center. So there's a lot of challenges. So actually what we have decided to do is that we have even decided to invite the employers and the HR practitioners and the in-house counsel for a training which we are having tomorrow, led by the Honorable Lady Justice Lynette Ndolo and myself and other practitioners, so that we can just give people insight at this point of time what are the emerging legal trends in which you can employ to manage your employees in terms of disciplining them, in terms of negotiating, in terms of CBAs, in terms of termination. How are you supposed to do all these processes? We know what the law says, but we also know the trends that comes with changes in situations. So those are some of the issues that we've invited employers to discuss tomorrow. And I think it is now high time that we started discussing them, because employers also have a lot of challenges. The high cost of living, taxes all over in this regime. They cannot maintain their, employee ratio. At some point, they'll want to let go of some. But how do you do it legally also? How do you send off your employees within the law? Or how do you make them understand that now you cannot meet the standards as an employer as a result of this? So there's a lot coming up. But there are legal trends in which has been defined by the recent cases and the directives which have been given by courts of law, the Employment and Labor Relations Court, on how now you can involve or you can discuss the issues of termination, dismissal, redundancy with your employees. One of the most interesting precedent we set when we were handling the case of, I don't know if you guys remember when we had a strike by the pilots for KQ. Yeah, that was in 2022. One of the precedent was set there where when we approached the court agreed that at some point you may vary the CBA. Even if the CBA had been registered, but parties can agree to accept certain critical elements and forgo others, you may vary the CBA. That has not been the norm. The norm has always been once a CBA is registered, it's a binding document as it is, and you cannot vary it. That is what even the doctors are holding on right now. Because this was the position we agreed in 2017, we are not giving up until it is fully implemented. So there are new trends that now they need to understand, and then the employers and even the unions need to understand how they can approach this system in settling the issues of trade disputes or issues arising from terminations and things like that between employers and employees.
To whom is benefit then handed to with these new trends? I'm just going to go off what you were saying just now, that it is possible, for example, to vary the boundaries of a CBA. It is upon this CBA that folks would have marked a number of things for the next 5 years, 4 years, however long. So in this case, we're looking at 2017 to 2021, 4 years, right? And it is upon this thing that you promised within these boundaries that you're going to operate. So are we saying that one of the trends now, according to the judicial system, is that it is possible to then vary some of these things? Is it possible that can you do that within the law and still remain legally sound?
You see, CBAs, employers and employees are party. Their engagement are governed by the contract of engagement they have. CBAs are agreement between people, which are then now registered to bind among themselves. Now, when parties therefore again meet and have a sound reasoning, and they feel that there are certain elements that we cannot implement at this point, but maybe we can give you a return to work formula on how we can implement the critical issues you want, but please, you can also let forgo a few, which we feel right now may not be practical for us to implement. For instance, of course, the government is perpetual, and we do not expect, because the old regime entered into this, and then new regime will come with new terms, it should be binding. But then there will be situations where the governor may say, look, right now we feel that because of the high cost of living, ideally, we agreed that the interns should be paid 200,000, but right now we can offer 150,000. But however, we are going to allow you guys to pursue postgraduate education at a full pay. You see, you're already now reducing a certain element of the CBA, but also giving a return to work formula, which they're getting in. So it is also a new system. And that is why even Justice Byram agreed, provided an opportunity for them and told them, look, this thing, yes, it was rigid. It cannot be rigid. Can you guys just talk and agree on a return formula, and some things can be forgo or something can be postponed upon implementation. So those are the trends. Initially, remember, even before this, when we were dealing, remember in 2016, there was an issue when we were dealing with the issue for the tea growers. They also had a CBA. But at that point, the court was clear on their position that CBA terms are binding and you are not going to negotiate it. The parties were all, of sound mind. There was no coercion. There was no undue influence. They all agreed on this. This was the point. So we are not going to, right now, try to vary certain aspect of it. But with time, people have understood that things change. Society change. I mean, the cost of living is up. The taxes, there's a lot. This country is crying to be broke. I don't know if it is. So there's a lot that probably may not be implemented at the same time. So that is why the court decided to, I think, probably issue such a ruling.
Okay.
Yeah.
So now, because we're going legally here, it doesn't matter who the parties are, whether it's two private parties, whether it's government or somebody else.
Yes.
Because I think some of the things CT says all the time is that situations like these pose an amazing opportunity for you to understand then what the law then provides, and robust conversation or discussion then creates an opportunity for understanding. Right? So yes, there's a binding agreement. One party chose for whatever reason not to stick by it, and then the discussions. Unfortunately, in this case, one party is the employer. Okay? At what point can they decide, like we have seen, that we can decide to just get rid of you if we have a binding agreement, we've not stuck to it, there's been a bit of irritation here and there until one party says, well, we're not coming to work because these are the requirements under which we would work. At what point can the employer say, we will then get rid of you if you're not ready to work?
Remember, an employer cannot terminate the contract of service of an employee because they are striking. Striking is a constitutional right under Article 41 for the employees to strike. The same way even employers also have a right of lockout. You see, so all of them have this labor relations right. So you cannot therefore send an employee home because they're striking. That is a right. And remember that strikes are protected unless it is declared by the court as unprotected strike. And on which when it's declared by court as unprotected strike, you can still not proceed to terminate them. You need to seek leave of court in terminating them. So it is hard, more so when employees now are raising or are striking on an issue that is already a legally binding document. It will be hard for you to terminate them. The only option an employer will have at that point probably will be to seek leave on court on how to deal with this matter, which I have seen them doing. I have seen them going back and forth, in court for determination on this. Because remember, the Employment Act really protects the interest of the employee, and that is why the burden of proof is always given on the employer. And it only provides instances in which termination can be, executed upon employee. It provides in Section 35 that you can only terminate on a normal, misconduct of the employee through what we call termination on notice or leave in payment. And on redundancy. Remember, redundancy, it's where now it's at not fault of the employee. It is at the initiative of the employer, but now because of the situation, the employer cannot sustain the services of employee anymore. He cannot sustain them. And there's procedure in which employer must demonstrate that to everyone. Because even if you use, just your tricks or malicious procedures to terminate this person in disguise of redundancy, he will still be reinstated, or however he will be compensated for that. So there are procedures required for that. So it will be hard for an employer to enforce a termination on an employee arising from a strike, which is for the benefit or as a result of a legally binding document, not because of gross misconduct, not because of incapacity, not because of incompetence of the employee, but because of a document which was signed by the parties and which has become part of the contract. So that it will be hard for them.
You say it is hard.
Yes.
Meaning it is not impossible.
It is not impossible.
So under what circumstances would it be possible?
The only circumstance now it will be possible is when the employer has demonstrated that they have met the requirements or their end of bargain as per the CBA, and the employees have not met theirs, or the employees are bringing in new demands. And at that point now, you need leave of court for you to enforce that. Because unless the employees either introducing new terms or the employees are not willing to continue with work even after the employer have met the terms, then the employee, unless now they agree with the employer cannot then move to terminate the employee on that ground. But they can only terminate the employee if they feel the employee is now introducing new terms or they have met their end of bargain, but the employee is still adamant. And also remember, they'll still need the leave of court to do that.
Something you mentioned, which I found particularly interesting.
Yes.
When we were talking about the strike, you talked about an unprotected strike and a protected strike.
Yes.
How on earth does a strike become unprotected?
Now, remember, strike is a right of employee.
Yes.
They can strike in time. And remember, strike must be a group of employees. So if one person you decide to undermine, that is not a strike.
No, that's when you're absconding duty.
That is your absconding duty. That's your own. So when a community or when a group of employees have decided now, we are not going to work, we are suspending work to put pressure on the employer to give in to certain demands which we feel are necessary or are part of our contract, then now there is a strike. That is a right which is given to them, and it does not require notice unless there's a policy document in the institution on the procedure, not limiting the strike, but giving the procedure within how it should happen in the institution, then that policy should be followed. But where employer has moved the court to confirm that these people indeed are striking on matters which we have met as the employer, as per the contract or as per our policy document, and the court has declared that strike unprotected or unlawful, and the workers should return to work, and they still continue with their strike, then now that strike now become unprotected. In other words, it is not now lawful within the eyes of the law.
Is the current doctor strike protected or unprotected?
It is protected.
It is protected.
It is protected.
One of the issues that you've talked about, again, emerging now, is that they've been asked to return to work. That has happened several times.
Yes.
The head of public service, Felix Koske, has said return to work.
Yes.
Governors from across counties have said return to work.
Yes.
The CS, or else. Mm-hmm. The CS, Ministry of Health, has said return to work. That's one of the things that you mentioned.
Yes.
They've said return to work, and they've still, because we've had a conversation and we want to do 1, 2, 3, return to work.
Yes.
They've not returned to work. Does that remove the protection of the strike?
No. It is not the cabinet secretary to declare a strike unprotected or this government. Sometimes I look at them. These people also are drunk with power. I think too much power, and then they lose the focus. This is a problem you're facing in this country. You see, these people did not just wake up and then say, you know what, we are striking. These people have been patient from 2017. And I've gone through those letters because I'm also part of that team. Mm-hmm. I've gone through the letters, the notices they had sent to the ministry. Almost 15 of them, requesting the ministry, can we have a sit-up, and agreed on these things, on these issues, you see, the basic issues. And then they feel, in every CBA, now the most interesting part is, in every CBA, there's a critical, or the heart of a CBA, certain critical issues that you cannot rule out when you're settling. And so when we sit down and you want to rule out the critical issues and then deal with other issues, and you want these people to go back to work, then I think also you're not being real, or you're not being serious. I have heard the doctors, I have heard what the government is saying. The doctors have made it clear, give us a reasonable return to work formula.
That's it.
That is it. Give us a reasonable return to work formula. We are not asking you to implement all these things at once. You see, but give us a reasonable return to work formula. What are you going to do between now and 2 years? In the next 2 years, what are you dealing with? Then what are you tell us how you are going to spread it. Don't just hold it and say, we will deal with it later. I mean, that is not being, fair. That's not being fair. That's not, negotiating in good faith. I have a problem in the way this government is approaching issues, more so when it comes to issues of professionals or issues of their employees. It is a dictatorial system. You either do it or else. Do it or else. Okay, suppose all doctors now say, we are not going to work. We are going to sit at home and then let you. I've heard them saying they'll go and hire some doctors from where? Where are they going to get all the doctors to hire? From where? Now they can't pay this one 200,000. Those ones, how much are they going to pay them? You see, so there are certain things. I think intimidation is old school. It cannot work in this country and this era right now. The sooner the government realize that they need to sit down and understand the situation, because after the doctors, the nurses here, the laboratory, whatever, they will be clinical officers. They're all over. I mean, teachers will start coming out. Will you suspend everyone? You go. We are going to look for new workforce from Uganda or from Tanzania. It cannot work. So it's a problem we have. The government, who is the big brother, who should be holding the higher responsibility, has decided not to. And so the people who are seeking help, or who want a CBA which was signed or which was ratified by all these parties, are now feeling that it's going to be the same system forever. So even the future doctors will not be safe anymore.
Our guest this hour is Kepher Ojijo, an advocate of the High Court, and we're looking at some of these strike issues. So, based on some of the things that you said, Wakili,
Yes.
we have seen, after conversations yesterday
Yes.
and reports today,
Yes.
that regardless of the legality or illegality that you speak of,
Yes.
termination notices have been given to some doctors around the country.
They're null and void. I think they're misinformed.
Who?
The governors, they need to read their law properly. They need to go back and read the Employment Act. That's not how you terminate employees when they're on strike. You see, this hurry of all those are just intimidation. That's why I'm saying there are some showed intimidation that will really, will really embarrass them at a later date, because I can tell you for sure they will be reinstated. They will be reinstated. That I can tell you for sure. They will be reinstated. You see, doctors are not striking on things of illegality. Doctors have invoked a strike based on a registered CBA which is binding, on a document which is binding. Remember, this document was also given timeline of its implementation. The timeline is lapsing. It has not been implemented. The only tool an employee is given in such a situation is strike. You see? And until such a time that the now courts declare that strike to be unprotected, then they can take such a decision. The court has not pronounced itself on that yet. The court told them, still negotiate. And when you're negotiating, do not come with terms. You know, this idea when people are going to negotiate, they already have conditions. We are not going to discuss this. We are not going to discuss this. This is what we are going to discuss. What type of negotiation is that? The court told them a clear position. You cannot have a condition in when parties are negotiating in a table. That is not negotiations. Those are terms. You're giving people terms. Can you guys agree and see a way in which you are going to probably implement the CBA? The courts understand that it may not be implemented all at once, but can you give a clear return to work formula, which is reasonable, which even when presented before the court can see and say, ideally, this is reasonable. But they have refused. They're just saying we don't have. Now, each other now throwing responsibility to the county government is throwing it to the national government. The national government is not throwing it to the county government. You see, if I were one of the governors, or maybe let me say the it's called the COG for the governors.
Yes, Council of Governors chair.
Yes, the chair of the Council of Governors. If I was the chair of the Council of Governors, probably I would call my colleagues and sit down and say, you know what we need to do, let us map out our responsibility in this CBA, because the CBA cuts between both the national and the county government. Let's map out our responsibility in this CBA. Let us present our formula on our responsibility, because the national government seems like they don't care, they're not going to do anything. They have said, the president stood and said, we don't have money. All of them are now singing to that. We don't have money, period. So if we were the governors, because the most, the worst hit places are the counties. That is where the doctors work. Doctors are employee of the counties, Map out your responsibility and then provide a return to work formula on your responsibility to the doctors, and tell them this is what we can provide as us. For the national government, we cannot do anything because this is their position. Then the doctors decide to do, they can now decide what to do with that, so long as it's reasonable and it's presentable. But if they're also now singing the same tune that the national government is singing and telling these people, you know what, there's no money, even as we don't have. If the national government doesn't have that money, even as we do not have it. So what do? You come to work or we are sending you home. I mean, that cannot stand. Those termination letters are in vain. They will not be enforced.
Okay, what happens when the timelines for a CB expires?
When a timeline of a CB expires, there are two options. It can be extended by the mutual consent of the parties, or two, the parties can register a fresh CBA on the same. So that is how it is cured. When it is expired, then it's deemed out of effect. You cannot claim it. But the parties can have a leeway by mutual consent to extend it or register a fresh one. And remember, by the way, when you register a fresh one, you are now allowed to introduce new terms or to vary some of the terms which was existing in the old CBA.
Which tells me that it would be in the government's interest if it expired.
Probably that's what they're buying. But you see, doctors also know. That's why they're saying then we're not working. So let it expire and let people die.
It's a bit harsh, no?
A little harsh, but that's the reality where we are. I think you've been seeing on media, how people are suffering in the hospital. There are no doctors to attend to them, you see. But also, the politicians or the people who have the responsibility to do that also do not care, because them, they can afford any type of medication they wish, whether here or abroad. So they do not care. But what about the common mwananchi there? People are suffering because of the doctors, and that is why I'm telling the higher responsibility falls on the government as the big brother, as they need to provide a way. They need to have a discussion with these people. They have, in terms of the hierarchy of the power of arms, they hold it. They can have a conversation with these people. They have a right. They have the means to provide a return to work formula. Right now, I heard they want to purchase a new presidential jet.
It's in the paper.
Yeah, they want to purchase a new presidential jet.
The old one is broken.
No, they say it's old.
Yes, they say it's old.
And I said this morning that we have aircrafts that flew in 1945, which are still flying to date.
Can you imagine? And they can't pay doctors 200,000.
Aircrafts are like tractors. Those things can live forever.
I know. They were built in 70s, in 80s, you see. And they can't pay doctors 200,000. What are our priorities?
There's this larger discussion I'm seeing here, because whatever we are seeing here will set a precedent.
Yes.
Now, if we look at the discussions around it, it's a one-way discussion from what we see. Meaning, the government has demands which they want the doctors to accept.
Yes.
Okay? And it is clear they are not going to accept it, from what I've observed as well.
Yes.
Now, if I look at the effect of what we're calling the economic downturn that we have in this country, where employers are letting people go, we are looking at businesses shutting down. Now, in circumstances of that nature, when businesses are in distress, people will be let go of.
Yes.
And it is never a pleasant thing when someone is let go of.
Exactly.
Because if there isn't work in one industry, it means if there are similar industries, they will also not have work, because it is the same industry.
Exactly.
What then should the legal thinking be in such instances for an employer and for an employee?
We have written opinions and proposals even to the government in the ongoing strike. I personally have. I have met with the team of the KMPDU union leaders, and we have discussed this matter in depth with them. You see, all these people live in this country. All these people are aware of the times in which we are living them. And no one is so unreasonable that is coming on the table and saying implement it all. For instance, they are saying just deal with the critical part of the CBA and give us a proper, reasonable return to work formula. When we send it to the government side, they don't address it. Tomorrow you hear one of them in a funeral or somewhere in a rally. Already in her own decision, she has made a decision without consultation what is going to happen. We just hear it, or the doctors just hear it from funeral. it is a bad example we are setting even to employers in the private sectors. It's a bad example we are setting even to future leaders who will take the position, because then it will be a position people will have this mentality in this country that you just decide what to do. There are no regulations, there are no rules, there are nothing. This is our position and that's it. You do what you can do. So it is a problem, and unless the government, I wish the government will come with a proper proposal and put on the table that this is what we have. What is your say on it? I wish they would have done that.
There's an individual within government called the Attorney General. Is he not the advisor to the government?
But that guy has been crying left, right, and center that he's not been consulted in anything. He's on record saying that the government sidelined him in everything. He's never consulted. The government wants to consult people like Sudi and the rest they have around. So he's never consulted. The AG has been rendered the most useless office in this country so far in this regime.
By whom?
By the government. There are no opinions from AG you can see. There is nothing. I think this guy, ever since maybe he was appointed to that office, probably maybe has never even done any opinion to the state, because they do not even involve him in anything. The other day was before the Senate committee. You heard him what he was saying. That even he was not involved in this housing levy bill, nothing, he had no idea about it, he just saw it there.
That's damning, isn't it? Because
now that is your country.
he is the advisor.
He is the advisor
to the government.
Yes. And the person to be advised and decide, I don't need your advice. Just keep it to yourself. What do you do? What do you do?
See, I brought this up because under the circumstances we are in, one would have very much wanted to know what the AG has advised on this particular matter, because after all, it is his legal advice that would follow the fulcrum on which the government could act.
You have seen those meetings. Have you even seen a representative AG in those meetings? Nothing. You've only seen the Minister of Health. You've only seen Moses Kuria and other people. Not even a representative from the AG.
Service, yes.
Nothing from the representative AG. So even wonder, okay, fine. Suppose even guys were now to deal on the legal issues or the aspect in terms of bargaining. How are you going to do it? You see, the office of AG has never been involved in this process. And not only this, they have come out, there's an outcry from that office. They've come out to say that they are not involved in most critical matters involving the government or involving the state with other countries. So I don't know. That is the arrangement. I do not know. The person you advise do not want your advice, as there's nothing you can do about it.
How does this then explain what, if we look at, because the truth of the matter is that when you look at a workforce of a nation and you compare it to what is happening with the doctor's strike, this is actually a very small percentage of people who are dealing with a human resource problem right now. How does this then play out for the rest of the country? Folks who would be in a similar situation, whereby you're dealing with what you could be dismissed on, terminated for. How do you negotiate with the employer? You said that the Labor and Relations Court, Employee Relations Court actually does then try to really protect the employee. But here we are seeing that it's possible for somebody to essentially, bend you. How then can you ensure that you then as an employee are protected when it comes to certain things which you are viewing in right?
Now, the Employment Act, if you look at Section 35 all the way to Section 40, provide the rights of an employee. And what the courts will always do, the courts are seen as the first remedy for enforcement of the rights of employees. For instance, let me just use this common scenario. I've been told there are certain letters which have been issued for termination.
Yes, they are.
The first point of break will be to the Employment and Labor Relations Courts or to the labor officer. I know labor officer cannot do anything, so they'll go to the Employment and Labor Relations Court. And it will be the interpretation of that termination letter or dismissal letter. Does it meet the threshold set in Section 35 or in Section 43 of the Employment Act? When the court will interpret and find it does not meet the threshold, the court has certain responsibilities or certain ways in which it can then provide a direction on that, either through reinstatement or through what we call damages for termination for this person. In other words, you'll be computing this amount up to the time we are expecting this person to be on a retirement form. You see, so those are some of the rights employees do have. But also remember that this is a point, this is a relationship. It is based on a contract more than the legalities in it. So, however parties will agree, so long as it's legal and so long as there is no elements of undue influence, then the court will adopt that. So, if the employer and employee can move the court and say, look, we have presented this, and the employee says we have to presented this, the court is then given the opportunity to interpret and assess what then amounts to reasonability. If the court says that what the employer has presented before me is reasonable to work with now, then the court now will provide direction. And should the employee now not comply with that, then the termination letters will now be deemed to be effective, and they will not be protected by the court. But if that has not been presented before the court, and if the court has not declared that, then all these letters being issued are in vain.
What are grounds for dismissal? What are grounds for dismissal that can then be accepted regardless of what situation is ensuing at the moment?
Remember, dismissal, ideally the act anticipated as summary dismissal. Summary dismissal is only effected in extreme grounds, what we call gross misconduct, not just a misconduct, on gross misconduct. You see, gross misconduct, for instance, if right now maybe your junior just shows up here, and then start throwing, huge abuses at you, hurling huge abuses and not complying with anything you're saying, or shows up here drunk and throwing or disturbing everyone. Those are not just misconducts, those are now gross misconduct. So therefore, the law anticipates in gross misconduct, you can therefore enforce what we call summary dismissal. The advantage of summary dismissal is, number one, you will not be required to give a notice. Or if you give a notice, it may not be a complete notice as anticipated in the law or in the contract. So those are the grounds in which you can then invoke summary dismissal.
Can you appeal a summary dismissal?
Yes. Every termination can be appealed and can be challenged. Remember, all these processes, every termination requires what we call a disciplinary procedure. The employee must be given a chance, to defend herself in presence of someone, either a fellow employee or someone who is according her hearing there, to defend herself. Then after the decision has been made, he or she also must be given another opportunity again to appeal on that decision. So, however, whether it's on a summary dismissal, whether it's on a termination, whether it's on a redundancy, everyone must be given an opportunity to be heard and to appeal on that. So, it is a process. You cannot just decide to just throw letters of termination to them and then they go. And remember, for this one also, it's the reason why it is not the undoing, it is not a misconduct from the employees. The employees are demanding an execution of a valid document signed or executed by both parties. Yes.
One of the things that we are looking at today is that there was a 19-point agenda that needed to then be fulfilled, and this is what was being discussed by the doctors as well as government. So there's 19 issues raised by them, and we've seen that now 18 of those have been discussed. We don't know if they've been agreed upon and then been going to be implemented as is. They've been discussed, right? The 19th one is the issue of intern doctors and what is going to happen. You talk about trends, and that's where we started, whereby now elements of a CBA then can be re-looked at, revisited and said, okay guys, can we do 1, 2, 3, 4, 5? Those are trends that we've seen because of some of the precedents that have been set by some of the cases that you mentioned, whereby we said, okay, this is what is happening in different jurisdictions. This has happened in Kenya at some level, whereby we can say, because of the current situation, let's tinker with this thing a little bit and see a situation where everybody at least will go home happy, right? So it's possible that be done. But in this case, where there is a complete refusal to deal with that because of historical issues, that has been cited as well. In an event where the 18 of the 19 issues have been discussed and potentially or more or less agreed upon, and this one stickler, this one issue, the 19th one, has then not been addressed, would you then be able to say that the CBA, we want to see how this 119th issue would be the one that would see how we can play around with the CBA? Can you do that?
Remember, number one, it's not the duty of the employer to decide what is being implemented at CBA and what is not being implemented at the CBA.
But they're discussing both of them.
They're discussing both of them.
Yeah.
And as I told you before, remember, every CBA has a critical, or what we call the heart of that agreement for the parties. If we say that the substantive issue from all these issues is issue number 7, this is the most important issue we want to discuss, and then you discuss issue number 8, 10, 11 and 15, you have not discussed the heart of the CBA which they want to discuss. And it is not upon you to decide that now we have discussed 18, one has not been discussed, so we are done. Now you guys are just joking, you're not serious. It's not upon you to decide that. Where you feel as the employer that you have given your best, or you have discussed the critical issues which you feel should be as a start implementation, then you present those issues before the court and say, this is what we have discussed and what we have issued, and this is what they are saying about it. We feel that we have given a reasonable proposal of implementation of the CBA. Then the courts decide. It's not upon you to decide now we have given reasonable. If you don't want, you go home. No. And it's not upon you to decide what you're discussing and what you're not discussing. That is why the court say you cannot come with conditions in discussion. You see, just come and discuss the whole situation. Give a reasonable return to work formula where every party feel comfortable. If doctor says the 18 you're giving us is not important, give us a proposal in this one. Why will one issue become a serious threat if you can discuss it?
So does that give rise to speculation that there's just an I don't want to deal with this issue as opposed to I am unable to deal with this issue?
Most likely. You see, unless they demonstrate why they are unable to deal with it, these things must be practical and reasonable. Every person can see that, look, you're asking, maybe you're asking for 500,000. Look at our budget which has been allocated to us right now. This is what we have. If we give you 500,000, we are not going to meet A, B, C, D, which you have also allocated. So we cannot give that. Right now, what we can afford is 200,000. It's practical, it's reasonable, it's seeable. You see, but if you just say we are not going to discuss it, we are only discussing these ones. If you're not willing to discuss them, you just go. We are done. That is not now having good faith in discussion or implementation of CBA. Yeah.
One of the things that seem to be in my mind a sticking point, it's something we've discussed here at great length, is what seems to be the inability of political leaders to simply speak the truth about an issue and to address it as it actually is, so that the issue at hand is clear. It's not, there's nothing obfuscating about it. It's something you can see. And yet, when the matter is brought to be discussed by the parties concerned, what is being discussed seems to be fairly far removed from what actually ought to be discussed.
One of the tragedies for this country is that we do not know where to stop PR as politicians, and we're now to implement the reality or deal with issues there. I think our PR as politicians goes way beyond what is required, and that is why they lose the point. See, when you're campaigning, you can do a lot of PR and tell people what to do. That's fine. No one is following you. But when real issues are presented before you, can't play it anymore. See, so the diversion tactics, the theatrics of missing the point and blowing it or diverting it to something else has been the norm. You see, how many days right now? Ever since the doctor started strike?
30 what?
33
days? Yes.
44 now.
44 now?
Yeah.
Okay.
We're in the 44th day of strike. What has happened? For 44, it tells you the lack of seriousness. Did they not know that there will be no doctors in hospital? Did they not know that people will be suffering? Did they not know that, they will be grounded in terms of medical operation? They knew this. But how they handle it? Threats, stories, they see this not working, they look for this, they look for it, instead of going to the real issues. Doctors are not interested in what you say in burials or side. Sit them down and say, look, I've heard you, this is what we have. This is the reality of what we have. This is the position. If you're telling doctors that the government is broke, we don't have money, and you've already aligned the list of CAS you're going to employ. One of them you're going to pay over 780,000
per month.
That is devoid of the allowances and everything. Over $1 million plus one person. You have aligned the list. You've aligned the list of the things you want to do. You are building houses. You see, it's important to build houses right now. Like Kenyans do not have places to live. Now we went to hire a new jet for you. I mean, it is not being real. That is why I'm telling you, sit down and tell these people, look, even us, we've cut costs in this because we can't afford. This is what we can do. But if you're telling them we don't have money and they see the things you're doing, those are the priority for yourself, then you're also not becoming serious. I think every nation that has ever thrived has given the best to its, medical sectors. You see, health is one of the fundamentals of every nation that has ever thrived.
It's actually a human right.
Yes, it is a human right. It is a basic need. You see, those are the things we were fighting with at the independence. Here.
Right.
You see, so up to now, look at where we are. As we want choppers, as we want, more offices, but our health is deteriorating.
Health is, I think it's got to the point where it's on its knees. Where do you see this going in the next couple of days? I think they're critical in terms of a decision that will be made. And when it comes to the law, when it comes to human resource element, when it comes to what politics we want to play around this, where it is critical that something is resolved quickly, that we know. But both sides seem adamant, are adamant. We know the doctors have said, don't play us again. It's not the first time that this has happened. Where do you see this going in the next couple of days? And what can we hopefully expect?
The buck stops with the president as the big man. He needs to put his house in order. He needs to have his priorities right. And he needs to have a conversation with his representatives on this. The doctors are not crazy. They have been living this condition for all this while. You see, they're very reasonable. Let's give them... You see, what I love what South Africans did. They also had a similar problem in 2021. I like what they did. What did the president do? The president went himself to the negotiating table and said, you know what, I've come here. I want to listen. And listen to them and say, what, this is what we are going to give you. And ties. At some point, you need to also to understand the psychology of the people you're dealing with. You see, the psychology of the people you're dealing with. If B is what we want, and there's A, C, and F, B, you can offer A, C, and F, and B is where our mind are. Give B and then decline these other ones. You shall have still done the same thing. You see, it's just psychological. You don't have to fight with everyone.
Indeed.
Some people, you must have to learn the art of understanding the psychology of people. So I think the backstop with the president. If that is not the position, then I think this matter will go back to the courts, and the courts will decide the way forward. Because I think people are now tired. It's over 44 days. Still, healthcare is in chaos. So the courts will give direction. Indeed. But how I wish that the government just, took this a little bit seriously, and then have a discussion on CBO with good heart.
With good heart.
Then we'll be in a better situation.
It will be an interesting couple of days or weeks and seeing what happens with that. Kepher Ojijo, thank you for being here this morning, an advocate of the High Court, as we go through some of these issues and one of the biggest human resource issues affecting the country today. Asante Sana for joining us. We hope to talk with you again in the future.
Thank you so much.
This is The Situation Room, the only way to start your day.